We are back with Professor David Blight, the Sterling Professor of History and African American Studies at Yale University, Pulitzer-winning author of an extraordinary book on Frederick Douglass. We're digging into a powerful article that Professor Blight, you wrote in The Atlantic about the assault on birthright citizenship from the Trump administration, which is, I think, of renewed relevance. You published this just a couple of weeks ago, but of renewed relevance. What was the name of the order? Restoring the value of citizenship. I mean, protecting the meaning and value of American citizenship. We're taping this a day after we got the announcement that Trump plans to be selling off green cards for $5 million a pop, the new gold card and the kind of golden ticket to American citizenship, which is rich and disturbing, particularly against the backdrop of this assault on birthright citizenship. Thanks so much for joining us. Could you give us, the argument you lay out in this Atlantic piece? We'll link it in the show notes here, but wanted to have you go over it with us before we dig in.
Sure, glad to, and thank you to Midas Touch and both of you for having me on. My argument in that piece is that birthright citizenship is not only part of the Constitution, it's in Section 1, Line 1, Section 1 of the 14th Amendment. It is, in my view, and I think I used the term in the piece, it's kind of an iron dome over American citizenship. It is a protection of those born here. If you're born here forever, you're a citizen with all the rights thereof. But it also sets up the rest of Section 1 of the 14th Amendment, which of course gives us due process, privileges and immunities language, although that's already in the Constitution. And then finally, equality before law. And the men who wrote that, the men who wrote the 14th Amendment, especially John Bingham, were very, very clear on what they were doing. And in the rigorous debates on the floor of the U.S. Congress, which anyone can read in the Congressional Globe if they choose to, they are very clear about at least one or two things. They meant birthright citizenship for the future, not just for the past. Yes, they are declaring birthright citizenship for the freed people, 4 million of them, who were just freed from slavery, pushing to 4.5 million by the time they passed this and ratified it in 1866, 67. But this is language, really a new constitution for the future. And they were in their right minds. They knew that future meant millions of new kinds of Americans coming to these shores. They had lived through, lest we forget, the massive Irish and German migration. Some of them were products of that in the 1840s and 50s, 30s, 40s, and 50s. Migration had almost completely cut off at the time of the Civil War, in the 4 years of the Civil War, because there was an all-out war going on. But that immigration was already beginning again in 66, 67, 68. And explicitly in congressional debate, especially John Bingham, author of Section 1, congressman from Ohio, made it very clear that he meant immigrants. He used the term immigrant, he used the term immigration to come. Now, so obviously where I'm going with that is that the argument now made by some that birthright citizenship is vulnerable because they only intended it in, and by the way, this is a claim of originalism in a frankly very specious way, that the argument is they only intended it for the freed people from slavery, not for future immigrants. And that's just not the case. And I could give you numerous examples of that if we need it.
Yeah, I mean, your description just now, and obviously in the article, is just so compelling, Professor. And it is really stunning to see these modern day right wingers trying to really alter the meaning, the plain language of that first section of the 14th Amendment. Not, and also obviously the other provisions in it with the immunity decision, but also just to try to reinvent history and lie about it. In my view, this idea that that it doesn't mean what we've all thought it meant. It doesn't mean what the Supreme Court previously said it meant. It doesn't mean what other courts have said it meant. That it suddenly can mean something new just because we have these new people in positions of power who loathe, who have just such antipathy toward immigrants. The idea of the way the radical Republicans of that period, the 1860s, to try to distort their language is so troubling. I wonder what your thoughts are, though, before that immunity decision last year that also excised language, in my view, from the plain language of the 14th Amendment in terms of how a person is barred from office if they're an insurrectionist, unless Congress repeals the bar, not until they create a new bar. Like, I'm wondering what your thoughts are, given that with the Roberts Court, where you think things are headed. Will we be able to sustain this plain language, the historical intent, and this longstanding set of precedents?
Well, in the Colorado, I believe, Anderson case, the Roberts Court, that's Section 3 of the 14th Amendment, which nobody knew until it was being tested. I mean, who knew except for those of us who teach about it, who knew there was a third section of the 14th Amendment, which was designed explicitly to prevent people who had engaged in insurrection against the United States to ever serve in office. Now, I think the Roberts Court has effectively erased that forever. I mean, by not using it and declaring that a state could not use it. Now, it could be resurrected in a future time of very different politics and presumably a very different court. It could be resurrected. It is still the language in the Constitution. But at the moment they decided that decision, I said, well, so much for Section 3. It may never get used again. And I don't know, you may or may not, there's no reason you would know. I was part of one of the many, many amicus briefs that were done about that. 4 historians we got together. It was Jill Lepore was our force of nature behind it. And then we got John Witt from the Yale Law School and none other than Drew Faust from Harvard. And we all bore down on that. We stayed right in our own lane. What we did is we went right into the debates over the 14th Amendment. We resurrected what they said they were doing and the precedents they claimed. And we were very careful to record how many times they even used the name of Jefferson Davis. They're trying to keep Jefferson Davis from ever being president of the United States again, and any other Confederates. That's what it was intended to do, because these people, by any definition, had engaged in an insurrection against the United States. But, of course, the politics of the court at this moment was such that they were never going to use that at that time. And there are all those reasons about, there's a campaign going on, he's a candidate for president, you can't alter the election. But what do they do the next summer in Roberts' immunity decision, but essentially rewrite part of Section 2 of the Constitution.
Yeah.
So the president can never be prosecuted for actions that are official to his office. I'm sorry, that's some of the worst history I think we've ever seen in a Supreme Court decision.
Yeah.
Answer your question. Section 3 of the 14th is as good as gone.
Yeah, and the question is can we have confidence that Section 1 will hold, given what this Roberts Court has done?
Well, everybody seems to. I mean, you all listen to more commentary than I do, probably. Everybody seems to be, even my friends here. I'm not a lawyer. I'm not a law professor. My friends in the law school, they seem confident that no, the court's never going to kill birthright citizenship. Well, I don't have a lot of confidence in this court. They might modify. They might look for a way to modify. They might look for some kind of compromise around it that puts it under some kind of pressure. I don't know exactly what that would be. It is a reasonable thing to conclude that this essential part, whatever you want to call it, what it means to even be an American. You're born here.
Yeah.
And the idea that we would even tinker with that. That's why in my essay, I tried to go right, again, stay in my lane. I went right to the debates. I quoted the people who wrote it. What did they say they were doing? But then I also said, look, this is a sacred pledge. The millions who have come here, their children, my mother, born of German immigrants, American citizens.
And it strikes me, of course, that what you're doing here is engaging in exactly the type of originalism that they purport to be doing there, right? You're looking at the original public meaning, the intent of what they're doing. And I think this conversation about what they've done to other parts of the 14th Amendment, the way they completely distorted originalism to expand the powers of the executive under Article 2 of the Constitution in Trump versus United States suggests that something very different than law is afoot here. And that if you zoom out, and particularly if we think about what you said, I think perfectly about the 14th Amendment as sort of a second constitution.
It is.
It very much is, right? It's like, and it's
together. What actually holds us together? This crazy pluralistic society. But Section 1 of the 14th Amendment. That is
right.
Well, the Bill of Rights does too, and other elements of our legal structure. But that little section with its 2 sentences of the 14th Amendment is what we hold in common as much as anything.
Yeah.
We all have those 3 things.
And so to this concern you raised, Lisa, about, what they might do in this case, and, I think, compared to some of the other maneuvers by the Trump administration, the attempt to, end removal protections that Congress puts in place on independent agency heads. This has been a long-term agenda item for the right-wing legal movement that these justices are a part of. I think it's more likely that will go than this, but it's hard not to at least have a serious conversation about this question that on some level they're trying to erase that second founding, that second constitutional process of the creation of these Civil War era amendments. And I sort of joked at the top about this gold card, but it strikes me as sort of profound, particularly in the context of what you wrote about, Professor, in this piece about the blood and sacrifice and just the rupture of our nation that produced the values of equal dignity under law that seem now completely by the wayside.
Yeah, I mean, I did say in that essay, thanks for reminding me that the roots of the 14th Amendment are in over 700,000 dead in the Civil War. Did they all know exactly what they died for? No, nobody does when they die in the war. But think of it another way. If they keep making this phony originalist argument that 14th birthright citizenship only meant for the freed people from slavery, first of all, they got to give up all that nonsense. They've also been talking, I'm sorry to be so direct, but all that nonsense they've been talking about how it wasn't race-based. Remember how Ketanji Brown Jackson had to kind of school her colleagues in her first month or 2 on the court to let them realize, no, wait a minute. This was being done because they just freed 4 million slaves. They were black. It was race-based. Sorry about that. But the other thing they gotta just erase from our imagination if they can, and let's pray they can. I'll give you one little example. I just had a student in here. You won't believe this, but literally today. Well, I have him in every Wednesday. He's doing a senior thesis on a Japanese American family that went through the Japanese internment. They were the original couple met at Heart Mountain, which is one of the internment camps in Idaho. It's a long story, but he has found many descendants. In fact, it's a huge extended family of 3 and 4 generations. Many of them converted to Mormonism. It's a remarkable American story. They moved to Utah, now they're in Colorado, and on and on and on. But think about it. The parents of the people who were interred at Heart Mountain were born in Japan. The people interred at Hart Mountain had birthright citizenship. They were born here. And of course, all of their children and their children's children and children's children have birthright citizenship. But the original Japanese Americans, born abroad, okay. Are we going to tell the descendants of that couple who met while they were incarcerated for being Japanese, who had birthright citizenship, that their descendants don't? I mean, this is how absurd this could become. Um, and can we even comprehend how many stories like this are there? Of Chinese Americans, of Jamaican Americans, of God knows German Americans. This is part of the fabric, part of the DNA. It's a sacred part of our DNA if we really believe this experiment is worth hanging on to, and it surely is. It's right there in Section 1. Now, why do they go after birthright citizenship? We need some psychiatrists for part of that answer. But part of it's to instill fear in the entire immigrant population, perhaps. Part of it is a political move. It makes immigration even uglier if you want, if you can somehow denigrate birthright citizenship and anchor babies and all of that. I don't know. It's for the base, they say. Maybe it is. But they're tinkering here with something truly sacred. And they may know they're going to lose this one. But it seems like they're kind of shooting broadly here at almost everything that they haven't liked about this country for a very long time. And some of it will stick. Some of it may even succeed in the courts. And they may get to remake part of our country unless, we find ways to resist and stop them.
Yeah, I what you said was so eloquent, Professor, and that it is such a central component of being an American, that you're born here and that you have these privileges and immunities of citizenship by virtue of your birth. One of the proponents was basically saying, oh, this is just prospective. It doesn't apply retroactively, even though the way the administration characterized the order would be that if someone was here studying and they had a child here while they were, a student on a student visa, that their child would not be a U.S. citizen. And there's no doubt that these anti-immigrant, sort of very partisan people who are pushing this, if they were to succeed before the Supreme Court, would of course then apply it retrospectively. They would of course say, oh, Kamala Harris is somehow not a citizen, even though she was born here.
Why
because
not do that?
Yeah. And so,
well, there's that provision in the executive order that people started calling the Kamala Harris provision.
Yeah.
And there is a provision this was tested, of course. It was not intended for the sons and daughters of diplomats who are temporarily here representing their country. They're not citizens if they're born. They're citizens of their
Right.
parents.
You can't even give them a parking ticket or hold them into court for violating a lease, because diplomats are the only ones who are not subject to, U.S. jurisdiction.
We have diplomatic immunity and presidential immunity now.
Yeah.
I don't know how much further how about professor immunity? I want professor immunity.
I was going to say, though, Professor, it's an honor to meet you as a scholar of Frederick Douglass, my hero. I carry this pin with me everywhere.
All right.
It says, power concedes nothing without demand. It never did, and it never will. And so I just want to thank you for your tremendous scholarship on the great hero, Frederick Douglass, but also obviously your contribution to the conversation here about the enormous centrality of birthright citizenship to the American experience.
Douglass used that very line. It's in a speech at the peak of the crisis over slavery in the 1850s. It's a fairly despairing moment. It comes right after the Dred Scott case. It's like, how do you keep hope alive here? How do you keep fighting this fight when the Supreme Court just said Black people can never be citizens? Black people have no rights, period. Quote, no rights. Well, power never concedes anything without a struggle. It never did. It never will. it's like Douglas is saying, okay, I get it. We're really worried. I'm with you, but never give up. And he didn't, actually. So.
And thank you so much, Professor, for not giving up. Really appreciate your time, all of your work, and would love to stay in touch and have you back on as you continue to document and sound the alarm about these assaults on our history and our freedoms. Until next time, please don't forget to like and subscribe to Court Accountability and Legal AF. Check us out at Tilted Scales on Substack and at courtaccountability.org. Dr. Blight, thank you so much for your time. Until next time.
Thank you. Take care.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.